Assalamualaikum and hello, my name is Nur Jafar from KBA 2495A. In this video, I will be presenting one of the case law in Islamic finance in Malaysia. By the way, the case is about the Muhammad alias Ibrahim against RHB Bank Berhad and another. In this video, I will discuss around 6 parts, which are: firstly is I will summarize the case fact. Secondly, who involved in this case? Thirdly, which court are governed this case? Fourthly, what are the issues arise in this case? Fifth, what are the principles laid down by the court? And sixth, lastly, the decisions by the court. Now, I will summarize the fact regarding what happened in this case. But before I'm summarizing the case what's going on, let me see who are involved in this particular case. Muhammad alias Ibrahim is a plaintiff, while RHB Bank is the first defendant and the second defendant is another. While in this case, the plaintiff, which is Muhammad alias bin Ibrahim, had proposed to build a bungalow on a plot of the land. The first defendant, RHB Bank, had demanded and purchased many Islamic banking facilities for their purpose. On 8 March 2005, in terms of service, assets and liabilities of the first defendant were vested in the second defendant. Unfortunately, there is misunderstanding occurred between the plaintiff and the defendants over the services that were considered to be unsafe for occupancy after the bungalow house was not found. The lawsuit was brought by the plaintiff to make the facility arrangement null and without effect. The plaintiff applied to throw out the claim of the plaintiff, but unsuccessfully. Some Sharia issues arose during the striking request, which it required the reference to the Sharia Advisory Council pursuant to sections 50C and 57 of the Central Bank Malaysia Act 2019. The petitioner admits that the above sections 50C and 57 were attributes of the federal institutions and seeking to declare it void. Okay, now let me move to the decided court of this case. The court that decided this case is High Court in Kuala Lumpur. Did you know what are the issues arise in this case of Muhammad alias Ibrahim against RHB Bank Berhad and another? Okay, the issues arise regarding this case is about the house financing using the Islamic banking facilities, which is by Bithaman Ajil BBA. So, what could be the issues for this case? For the first one is whether Central Bank of Malaysia ultra buyers. Secondly, whether Sharia Advisory Council SAC has power to decide the case issues arise. Thirdly, is whether the court bound to follow the Sharia Advisory Council SAC. Before making any decisions, they are required to make references from those who are really qualified. And next, let me move to the principle laid down by the court. The principle laid down by the court is the references to the Sharia Advisory Council pursuant to sections 50C and 57 of the Central Bank of Malaysia Act 2009. Under sections 56 Central Bank of Malaysia 2009, if there is any questions about Sharia matter occurs in any proceeding relating to Islamic financial transaction before any arbitrator or judge arbitrator, as the case may be short to: first is take into account any published SAC ruling and for its ruling. Second is must be refer such an issue to the Sharia Advisory Council. Thus, the Secretary shall be presented with any order for advice or a decision from the SAC under this Act or any other statute. Next is under Section 57 Central Bank of Malaysia, if there is any determination taken by the SAC pursuant to a reference made pursuant to this part shall be binding on the Islamic financial institution referred to in Section 55 to the court or arbitrator and also Section 56. After reviewing the principle that has been laid down, the court has made the decisions. The plaintiff is also not entitled to the declarations he is seeking. This case is now due to be referred to the Deputy Registrator on 11 May 2011 for case management. Since this is the first time for the court is grappling with the latest Central Bank of Malaysia 2009 under Section 50C and 57, there is no cause order. Accordingly, the plaintiff motion for a declaration requested to be rejected with the order as to cause. Thanks for watching my previous video. That's all from me. Thank you. Now let's see one animation video in summarizing the whole case. Hope you are enjoying in watching the video.